I'd like to preserve 5 minutes for rebuttal, Your Honor. My name is Fred Vollrath. I represent KNEF today. We are here today on the issue of whether or not the trial court below abused its discretion in awarding attorney's fees of $5,040 for a claimed 12.6 hours of work for the preparation and arguing of a simple motion for sanctions.
Mr. Vollrath,
yes, ma'am.
Let me get right to the heart of what's bothering me about this. We do not have the motion to enforce in our record, correct?
I do not recall, Your Honor.
In our record?
I do not recall, Your Honor.
Okay, I think we have the order on it, but we don't have the motion itself. And we also don't have the transcript of the hearing on the motion to enforce, correct?
That's correct.
So you are asking us to second guess the trial court's assessment of how long these were or how complicated they were or how much time it took to prepare the motion to enforce and to prepare for the hearing on the motion to enforce when we don't even have those before us. So even if we were inclined to second guess the trial court, what could we base that? What do we have to base that on?
Well, the trial court made a very detailed finding in its order, finding for the sanctions. The question really is whether or not 12.6 hours are required in order by an attorney with over 35 years experience at $400 an hour is required to file a relatively simple motion for sanctions. There was no question that the deadline that the court set forth in its pretrial conference order was missed, although the witnesses, except for expert witnesses, were the same as those listed by the plaintiff in the case. The total amount involved in this case, which was an action out of contract, or at least it started off at that, was $15,000. The only issue before the court was what the appropriate sanction would be for missing the deadline. And the sanctions that the court could impose, again, were relatively limited. The court could do what it did, and that is say, well, you didn't list the witnesses, so you can't call them. Or the court could have provided any other number of sanctions less than that, but that's what the court chose to do. So the issues were relatively simple. There isn't any question about whether or not the court had the discretion to impose sanctions, or even the sanctions in which it imposed. The question is whether or not to file what amounted to a simple motion for sanctions. The deadline was missed, Your Honor. We'd ask you to strike the witness list. That's what it came down to. That doesn't require, I would submit for this court's consideration, 12.6 hours of attorney time to present and argue. Now, the case law says that while a trial court has wide discretion in making these determinations.
And we would have to find that the trial court abused its discretion to do anything about this. Right?
Yes, you would have to find, looking at the order that was presented and the issues that were involved.
Well, what we'd have to find is that no reasonable judge would have done this.
That's correct, and that's what we're asking this court to do.
Okay.
Is to find
more reasonable, I guess.
Yeah, and that's what the case law allows. It allows this court to, in essence, substitute its judgment for that of the trial court to see whether or not there was a clear abuse of discretion to award $5,000 to file a simple motion for sanctions.
Wasn't the hearing on that motion over 1 hour in length?
Yes, it probably was.
All right. And so, again, how do we know what a simple hearing, a simple motion that's fairly straightforward would not seem to be more than an hour. How do we know how complex the issue was if we don't have a transcript of that
Well,
hearing or the motion.
Well, one of the reasons why there's not a transcript is because one of the arguments, of course, before this court today is proportionality as to what you're charging for what is involved.
But our problem is, and I don't mean to interrupt you, I apologize for that, but our problem is, following his point is, there was testimony about what work was done, what work was needed to be done. There were lawyers who took positions on whether that was reasonable, and we don't have the benefit of any of that. What you're asking us to do is to assume that this was a very simple matter without any evidence whatsoever. And I was a trial lawyer for 17 years, a trial judge for 12 years. I have an idea what this was about. But every case is different. Sometimes there are wrinkles and things that you don't know about. And without a transcript, we have no way of knowing, was there a wrinkle in this case or not?
Well, what was the wrinkle? The deadline was missed. There was no argument about that. The deadline was missed. The only question was what sanctions should be imposed. And the basic sanctions are you don't get to use your witnesses if you didn't list them. That was the issue. It doesn't take, I would suggest for the court's consideration, that doesn't take 12.6 hours. It requires, comes now the plaintiff by and through the undersigned attorney and moves this honorable court to impose sanctions against the defendant because they missed the deadline of whatever date it was, and we would ask that the witnesses be struck, period. That's the issue. That doesn't take 12.6 hours. Assuming it took an hour to put together the motion, assuming that there was an hour's worth of argument over what the sanctions should be.
Well, presumptively, and again, we don't know, but I guess there was lawyers who were called to talk about the reasonableness of the time involved, so those lawyers had to be rounded up, they had to be talked with, they had to be prepared for, they had to be put on and questioned, and so there is, I mean, I don't know how much time all this takes, but it's more than an hour or two.
Well, the question then is, does it take 12.6 hours?
That's the problem. We're not going to know that without a transcript.
Well, again,
You're asking us to guess at that.
Well, we're not exactly asking you to guess. You look at what the trial judge's order was, and he wrote a detailed order. And again, would Jabez, the plaintiff in this case, have spent $5,000 to argue a motion for sanctions over a case involving $15,000? I suggest for this court's consideration, no one would do that. And as the cases cited in the briefs point out, you have to look at the proportionality. Why didn't we spend $3,000 or $4,000 to argue this motion over a $5,000 fee? Because it's hard to come in front of the court and say that the amount of attorney's fees should be reduced, that it was a gross abuse of discretion for the court to award $5,000 on a simple motion for sanctions over $15,000, and then come in here and say, well, yeah, we're arguing over $5,000, and we spent $3,000 or $3,500 to get here. Because certainly the argument would be, well, didn't you do the same thing? Aren't you spending a disproportional amount arguing over $5,000? Which would be the valid argument. As the case law says, there's more than simply, let's assume he put in 12.6 hours. Let's assume he did. The question becomes whether or not that is a reasonable thing to do. That an attorney with 35 years or more of experience, charging $400 an hour, would take 12.6 hours. Let's assume he did.
Maybe he thought it was worth it because if they won on the motion, that would force a settlement and everything would end right there. I mean, maybe it was just a strategic move that we get their experts excluded or their witnesses excluded, and the case ends right there for $5,000.
But again, the issue there is that it wouldn't have taken, I would suggest for the court's consideration, 12.6 hours to do that. The deadline was missed. What are the sanctions? Those are the only issues. Does that take 12.6 hours at $400 an hour for an experienced attorney with 35 years experience? It isn't. That could have been, they're obviously entitled to a fee for that, but I would suggest for the court's consideration that had the court awarded $1,000, said, okay, we're going to award $1,000 for that, we wouldn't be here. But to suggest that it takes 12.6 hours, and as the case law says, this court can draw on its own experience as judges and as attorneys as to whether or not it would reasonably take 12.6 hours. If this court believes it would reasonably take 12.6 hours, we lose. But the case law allows KNEF, in this particular case, to ask this court to look at the issue and make a determination as to whether or not that is reasonable. I mean, this is not a complicated issue, which of course is the issue. It's not a complicated issue. It's a very simple issue that it wouldn't take a half hour for an experienced attorney to draft that motion, although you could take longer. You could take apparently 12.6 hours to do it. But I suggest with the court's consideration, it would not take 12.6 hours to do that. It would take maybe an hour for the motion, if that, and then let's assume it was 2 hours. Let's assume it was 3 hours for the hearing. Let's assume that you were going to argue something more than it took that much time to say he missed the deadline. Never disputed. That wasn't disputed. And let's assume that there was an argument over sanctions. The sanctions were limited and totally within the discretion of the court. That's the central issue in this case, is whether or not the fee charged was disproportional to what was involved. So, at the risk of repeating myself, I will end it on that note. Thank you.
Thank you.
Thank you.
Good morning, Your Honors. My name is Attorney John Fleck from Brayton, Florida, and I represent Jabez Restorations, Inc., the appellee in this case. I won't make myself too long-winded, but I'm noted for that. But I wanted to hit the first really important issue. Opposing counsel came up here and said it was a simple motion without any record evidence of that. That's making factual representations to the court without record evidence. Second, he never had this appeal consolidated with the other appeal on which they did appeal the judge's decision to strike the witnesses. So he comes in today, he says, oh, that was a simple issue, wasn't complicated, the judge could do whatever he wanted, yet he failed to have this appeal consolidated with the other appeal they took, which they argued in that appeal, which is part of the second DCA, that the judge abused his discretion in striking the witnesses in the second DCA, ruled against them. So in 1 minute, in the other appeal, he's saying, oh, the judge abused his discretion in doing all this, yet then in the other hand, he comes in today and says, oh, that was just a simple matter, no big deal. The judge had a right to do whatever he did and there was no legal thing, yet he took an appeal on the judge's decision and the second DCA denied that appeal. So he's taken inconsistent positions on the same issue one when it benefits him one way, and the second when it benefits him the other way. Moreover, it was his responsibility to prepare the record. He didn't do that. The motion's not in the record. There's no transcript of the hearing of all the cases that he argued, whatever evidence was presented at that hearing, how complicated that hearing was. Moreover, as you saw, on a case like this, the striking of the witnesses, as you know, is considered abuse of discretion unless the court has no alternative or so on. And as you noticed, in the other appeal, they continued to say the judge abused his discretion, and that it went so far as they said to the judge, we don't want a continuance, yet in the other appeal, they said the judge abused his discretion and so on, and that was one of the issues of them coming forth at the hearing, which they didn't have transcribed, saying, oh, we don't want a continuance, then in appeals and things, taking inconsistent positions. And respectfully, when they asked you to put yourself in the position of the trial judge, you know, when you really read the case law, this is, and I'm not saying this is the appropriate case, but when we talk about abuse of discretion, and then we get to factual issues, the law over the last 100 years has commingled and jumbled it together what abuse of discretion means. Abuse of discretion means that there's no reasonable factual basis upon which the judge could make that conclusion. First thing we learned in law school when we went to law school, I'm assuming they still teach it, there's a drunk felon laying there and 12 nuns, and the 12 nuns say one thing and the drunk felon says another, and they tell you the jury has a right to believe whomever they want. That's why we have a trier of fact. And we as a system say, we're going to elevate the trier of fact to the most important position. So when we say a judge abused his discretion, what that really means is there's no plausible evidence in the record to support the judge's decision. Well, in this case, there was my expert witness who even reduced my time by a little bit. There was my testimony from the record. There was my client's testimony from the record in which she said that she thought it was reasonable, and we discussed that. So when opposing counsel comes in and says it's not reasonable, we had a judge who had a multitude of evidence upon which to make his decision, and he did. What counsel is asking you to do is to say, oh, I would have made a different decision. No. If we're going to do that, then we don't need to have a trial judge. We'll just have an appellate judges make the decision on every case. What this case opens us up to is every single attorney fee case in which there's two opposing experts, then we're going to come into court on every case and say that was unreasonable because counsel deems it unreasonable. Moreover, when you look at their expert, he's an expert who hardly ever practices in Manatee County, not familiar with the judge. We have a trial judge, which is not part of the record, one of the most distinguished trial judges. Are we going to say that that judge should be removed from the bench because he can't make a reasonable decision? So isn't that what the appellate court, when the appellate court says that a judge abused his discretion, there was no evidence from which he could make that decision? Aren't we really then talking about the ability of that person who is ever the trial judge to say, well, really, should you be sitting as a trial judge when, in fact, you're not able to make a reasonable decision? Thank you so much.
Thank you. Mr. Volrath, you have 5 minutes if you want them.
Thank you, Ron. No one's asking this court to remove the judge from the bench. In fact, I think he retired. But as Miller versus First American Bank tells us, the knowledge and common sense apply where billable hours and rates are generally disproportional to the services provided, which of course is what our argument is here today. The court said there is an economic relationship to almost every legal service in the marketplace. The value of any professional service is almost always a function of the relationship to something else. No matter how much time was spent or how good the advocate, the fair price of some legal victories simply could not exceed some relevant sum, not determined alone by hours or rates, which is what we're asking here today. We're not saying that the judge was not entitled to award an attorney's fees. What we're arguing is that it was grossly disproportional to the services provided. As other courts have found, which we cited in the brief, the court reduced a fee of $14,200 for 71 hours of work on a routine child support modification. The court said that it was not unreasonable to reduce because the case involved no novel or complex issues, and the claimant's attorney should have been able to handle the case in one-half the time claimed. Which is the only argument here, is that the fee for a simple motion for sanctions with limited ability as to what the remedy would be, $5,000 over an issue, a case with a total of $15,000 at stake, that it was simply an abuse of discretion, which I hope this court will find and reduce the amount. I would suggest that a reasonable amount would have been $1,000. Thank you.